political question. We're just saying you can't use race as a factor. Is that what they did in Calais, or am I misunderstanding it?
That's basically it. You can use it to remedy, past discrimination that you've proven. But that wasn't the case in the Calais case. The other side didn't prove it.
Well, but once again, you're muddying that water, man. Did the court, or did it not, say that you can't use race to draw a congressional district?
In this sharp Senate Judiciary Committee hearing clip, Senator John Kennedy of Louisiana does what he does best, cuts through the legalese with plain-spoken, folksy questions that put witnesses on the spot. The topic is the Supreme Court's recent decision, essentially banning racial gerrymandering, drawing voting district lines primarily based on race. Kennedy zeroes in on Todd A. Cox, Associate Director Counsel at the NAACP Legal Defense and Education Fund.
Kennedy.
Thank you, Mr. Chairman. Mr. Grime, am I saying your name right?
You are, Senator.
You argued the Calais case?
I did.
Okay. I'm going to tell you my understanding of the case. And then, Mr. Cox, I'm going to ask you to tell me if Mr. Grime got it right. And Mr. Chamberlain, you can chime in if you would like. Are you familiar, Mr. Grime, with the Students for Fair Admissions case?
I am.
Okay, that's the case recently where the Supreme Court said you can't use race in college admissions. Now, here's what I heard the Supreme Court say in that case. I heard the Supreme Court say, look, colleges, we're not going to get into the admissions business. That's your business. We're just telling you you can't use race as a factor to admit anybody. Is that your understanding of the case?
Basically, yes. And they did a whole 14th Amendment.
Don't try to muddy the water to make it look deep, guys. I know you're all smart. I'm just trying to get to the bottom line. Am I wrong or right?
You're right.
Okay. Now, the way I read Calais is the Supreme Court is saying, look, first of all, these are political questions. And we're not going to tell the states how to draw congressional districts. We don't want to be in that business. That's a political question. We're just saying you can't use race as a factor. Is that what they did in Calais, or am I misunderstanding it?
That's basically it. You can use it to remedy, past discrimination that you've proven. But that wasn't the case in the Calais case. The other side didn't prove it.
Well, but once again, you're muddying that water, man. Did the court, or did it not, say that you can't use race to draw a congressional district?
In most cases, you can't unless the state, the person defending the map, shows that they had to use it because there was a showing of immediately past intentional discrimination, that they had to use race to unwind.
Okay.
Yeah.
Tell me whether he got it right, Mr. Cox.
Senator, quite frankly, the defense of the Calais case is such a tortured exercise. It's
Mr.
difficult.
Cox, I don't want to hear.
So I'm going to tell you what SFFA, how SFFA applies to Calais.
Did he get it right, or
he did not get it right? Okay. So under the application to discuss Calais, you have to really discuss what happened in the case that created the district that was challenged in Calais. That was Robinson.
All right.
The court required the state of Louisiana to redraw its plans pursuant to its findings of a Section 2 violation.
Look, I don't
That's
want to have a fight.
Justified the creation of the
plan. I don't
want
to have a fight. Can you just tell me, and you're smart, and I don't want to make this more complicated than it is. Tell me what he got right or wrong.
I'm telling you, what he got wrong was ignoring...
No, you're speaking like a lawyer, okay? And I'm tired of... I've listened to you gentlemen, okay? Let's just get down to it. Mr. Chamberlain, tell me what Mr. Grime got right or wrong.
He got it all right. You think I'm really going to tell the guy who argued and won Calais that he didn't understand what he was arguing?
Okay.
officer, and I'm totally respectful. Yeah, obviously, I think he's got a good handle on it.
I understand that, Mr. Cox. I don't mean to be rude, the importance of precedent and all that, but didn't the Supreme Court say, except in very narrow circumstances, you just can't use race to help a person, and you can't use race to harm a person, and that includes in drawing congressional districts?
In answering that question, I'm going to tell you that the Robinson Court, which gave rise to the district that was challenged in Calais, said that there was a violation of the Voting Rights Act, that it was required to draw a district or draw a redistricting plan that satisfied the Voting Rights Act, that allowed African Americans to elect candidates of choice.
You don't want to answer my question, do you, Mr. Cox?
I'm answering your question.
No, you're not.
Maybe an answer that you don't like and my colleagues don't.
No, you're not.
But I'm answering your question.
You're giving us another lecture, and this is not a common law class. Tell me in simple terms, is that not what the court said?
The court said a lot of things that were inaccurate. So that court said you can't use race at all in drawing plans. We disagree with that. But what the court really did was say that you can prove race you can prove there's intentional discrimination, which is in violation of this Congress's intent. It also sprinkled partisanship as a defense for any challenge to any challenge under Section 2.
All right, well, I'm about out of time. I can see, no disrespect, Mr. Cox, but you're not answering any of my questions. And I know you're disappointed in the decision. But let me put it another way. Do you think race should be used to help a person?
I don't understand that question. Race should be used to help a person?
Do you think race should be used to help a person?
I believe that if there is a racial violation of the law, that race discrimination, I believe a remedy that's race conscious can be required, yes.
Do you think race should be used to harm a person?
I don't really understand what that question
No, I didn't think you would. Mr. Chamberlain, do you think it's fair in America to use race to help a person at the expense of other races?
No.
Do you think it's fair in America to use race to hurt another person?
No.
How about you, Mr. Graham?
Absolutely not. Race should not be used to help or hurt an individual.
And no disrespect to Mr. Cox. He's very bright. I can see that. And I've been where you've been. You know, when you get in front of a court of appeal and you're losing, you want to kind of obfuscate. I get it. But that to me is what the court's saying here in all these cases. We're not going to try to run your business. Not in the college admissions, not in drawn districts. But you can't use race. Period. End of discussion. And I think that's what the Constitution says and what most Americans support. I know you're disappointed, Mr. Cox.
I'm not disappointed, I'm outraged.
But that's what the Constitution says.
Well, can I add one more thing that's
Sure.
not quite exactly addressing what you asked? I do think there's a role for a co-equal branch of government, Congress, to make its own determination regarding how it wants its laws enforced. And I would urge this Congress to reconsider Calais in that light.
Yeah, but you and I are both aware that the United States Supreme Court has full authority to pass on the constitutionality of a statute. Come on, you know that. I'm sorry, Mr. Chairman.
If Mobile versus Bolden is any example of what can and can't happen, this Congress can take a look at Calais and say, actually, you got it wrong. And you actually didn't interpret what we intended in 1982 correctly.
The problem with your argument is, I don't think race should be used to help a person because of his race. And I don't think race should be used to harm a person because of his or her race. And I think that's what most Americans believe. And if you don't believe the opposite, and you clearly do, this is America. You can believe what you want. But the Supreme Court is deciding these cases.
I hear you.
Saying race is off the table.
I hear you. And I believe as a civil rights lawyer that if you find a violation based on race, you need to craft a remedy that addresses that.
Sure.
Senator Whitehouse.
I'm sorry.
Kennedy starts politely. I don't mean to be rude, but you can feel the tension building. He's trying to pin down the witness's understanding of a key case, likely Alexander versus South Carolina, NAACP, or similar, asking Cox to react to his summary of the facts. The back and forth highlights a core Philosophical clash in American voting rights law. On one side, you have the traditional civil rights perspective represented by Cox. That race has been used historically to dilute minority voting power. So courts and legislatures sometimes need to consider race explicitly to create fair maps and remedy past discrimination. Cox argues that when there's a proven racial violation, the remedy should address it directly. Kennedy, channeling a colorblind constitutionalist view, pushes back hard. He presses on whether it's ever appropriate to make race the predominant factor in drawing district lines. His style is classic Kennedy. He uses simple analogies and direct hypotheticals that force the witness to either defend race-conscious policy openly or walk a tightrope. You see the frustration when the lawyer tries to nuance it. Race can be one factor among many, but not the main driver. This exchange is revealing because it exposes the post-Shelby County and recent SCOTUS shifts. The court has increasingly said the Voting Rights Act doesn't authorize unlimited race-based map drawing. The majority opinion basically says, treat voters as individuals, not as members of racial blocs. Critics like Cox worry this removes a crucial tool for protecting minority representation, especially in the South. Kennedy's most effective moments come when he asks variations of, if race is off the table, how do we fix this without creating new racial preferences? The witnesses' responses circle around historical context and ongoing disparities. But Kennedy keeps steering it back to the principle. Should government be in the business of sorting citizens into racial boxes for electoral advantage? It's a microcosm of America's bigger debate on race in public policy. One side sees acknowledging race as necessary justice. The other sees it as perpetuating division and violating the 14th Amendment's equal protection. Kennedy lands lines that resonate with many viewers. Don't muddy the water to make it look deep. Gets quoted in comments for a reason. The clip is only a few minutes long but packs a punch because it shows the discomfort when elite legal thinking collides with straightforward questions. I hear you, Cox says at one point, but the gulf remains. In an era where the Supreme Court is pulling back from race-based decision-making and admissions, contracting, and now redistricting, exchanges like this will keep happening. Kennedy isn't trying to win a law review argument. He's performing for the public, boiling complex jurisprudence down to, are we going to judge people by the content of their character or the color of their skin when we draw maps? Love him or hate him,